welcome you to this webinar that is being hosted by the Institute of Economic Affairs that will focus on this critical and timely topic, which is the abuse of power within the regulatory framework in Kenya. My name is Fiona Okadia and I work at the IEA. So just a bit of background on who the IEA is and what it does. So we're a public policy think tank that undertakes research and public education on key economic and topical issues in public affairs in Kenya. So we utilize these outcomes of research for public policy dialogue and also influencing the policy making process. So we do this across 5 programs. The first is the Economic Competition and Regulation Program, which is the program that is hosting today's webinar. We have the Public Finance Management, we have Futures and Foresight, we have Trade and Development, and we have Constitution, Law and the Economy. So in this landscape of commerce, the abuse of buyer power has emerged as a crucial concern, and it affects suppliers, it affects competition, and the overall economic ecosystem. So today we are honored as the Institute to have Dr. Njako of the Competition Authority of Kenya, who serves as a manager of buyer power, and she will be sharing valuable insights and knowledge on the regulatory framework that is governing buyer power in Kenya. So throughout this webinar, we hope to delve into various facets of this issue. So we want to explore the regulatory landscape that governs buyer power in Kenya. So shedding light on what are the policies, what are the guidelines that seek to maintain a fair and competitive marketplace. So we hope that by understanding the regulatory framework, then it would be a key area in terms of just addressing and preventing any types of abuses that might arise in future, and also for just members of the public to be able to understand what we mean by abuse of power. So Dr. Njako will take us through the various types of abuses, hopefully as well, just giving us case studies in the past in terms of in the Kenyan market. So just to offer practical examples in terms of just the different buyer power dynamics. So as we embark on this, let us just actively engage in the discussion. There'll be a plenary session at the end, so she'll have a few minutes to present, and then after that you can ask questions in regards to her presentation. If you're in the business community, that will be also an opportunity to just sharing your to be able to share your experiences. And we hope by doing so, we can then collectively contribute to a better understanding of this topic and working towards fostering a business environment that is not only fair, but also competitive and again, conducive to the economic growth. So without further ado, I invite Dr. Njako to take the virtual stage and share her experience on this critical topic. And thank you everyone for joining us and taking time to be able to be here to just listen to what we have to say for today. So Dr. Njako, karibu sana.
No, you're moving too fast. Let's go back. Let's go back to the previous slide. All right. So once again, my great apologies for the mishaps. I don't know whether to call them mishaps, but just the delays. Apologies. Let me progress. So the summary of my presentation. Okay, effectively, I had wanted us to look through abuse of buyer power, starting off with the context, and that's a background. I'd want to take us through a background of this area of enforcement under the Competition Act. I want to give us an overview of the regulatory framework. And of course, like I've said, before I get to the regulatory framework, what is the law? It's important that we get context, that we get background, because once we have background, then we appreciate what the law requires, and we appreciate the style, quote unquote, of enforcement even better. I will want to take us through the impact of abuse of buyer power. And on this, I'll touch on just generally, but then I'll try and touch on the Kenyan scenario. And then I'll give us some case studies. So in a nutshell, 4 parts. My presentation has 4 parts, which I intend to be done in 30 minutes or less. Fiona? So what is our context? First, there is a motivation for the law. We must understand what motivated abuse of buyer power provisions into our law. And just very simply, the motivation is the national economy. That is what brought us to where we are, the demands of the national economy. Because the reality is that, Fiona, you could just put the entire slide, all of the, yeah, just put the entire slide. Thank you. Now, so competition law is enforced for purposes of regulating the competition within the various sector in the economy, because active, vibrant competition ensures consumer welfare, and that is better prices, greater choice, better quality, but it also ensures that the various market players, each of them are able to contribute individually into growth of the economy, into the development of the economy as a whole. And so that if we are to take, for example, one sector, SMEs, for instance, SMEs, when there is vibrant competition, when they are supported to be able to exist within the economic space, they contribute up to 80%. They make up to 80% of all the businesses in this country. It's 80, 90, 96%, just generally across the world. But in developing jurisdictions, their value is even greater. And so it is important that each individual player is facilitated in the sense of a competitive environment within which they can then exist, they can then become efficient, they can invest in research and development, they can hire. And so basically abuse of buyer power provisions were incorporated for the value of individual market players in the general economy. But very specifically, we're looking at SMEs, the smaller market players. And the law as it is today, it's a bit limited, and later I'll address that issue. We only look at suppliers. And so we're talking about SMEs whose place in the market is as suppliers to typically bigger buyers. And the very impetus that brought us to where we are with abuse of buyer power provisions is the retail sector. And many of you will recall the challenges that this sector faced about the time Uchumi. You will remember Uchumi supermarket. I know most of you will do Nakumatt supermarket. And so these retailers had challenges which forced them to exit the market. But at the back end of that, their exit, it became very apparent that their suppliers were left with huge, in the sense that these retailers exited the market while owing there are many myriad small suppliers, volumes of delayed payments running, of course, in billions. If you remember the situation of Nakumatt, I believe it was 17.28 billion, one of those two figures. But that was the reality. And so the question was asked, how is it that a supplier is able to continue struggling, to continue providing, to continue supplying in a setup which is very untenable for them? And the answer became very apparent. The authority did an inquiry in 2016. State Department of Trade also did a study about the same time, 2016. And it was established that suppliers were operating in an environment where they were term takers. They were not able to negotiate, and they had to take very onerous terms of continual supply. And I'll be able to clarify what these terms could be. And so in 2016, the Competition Act number 12 of 2010 was amended the first time around to introduce 4 subsections on abuse of buyer power. So hitherto we had the usual abuse of dominance, restrictive trade practices, and then we had merger regulation. But now the law was amended in 2016 to introduce this new area of enforcement called abuse of buyer power. 2019, the act was expanded, and now we have 9 subsections, which are more detailed, which are more focused, and so we are able to enforce even better. How do we enforce? What is a framework? The framework is the Act, Competition Act number 12 of 2010, and then I'll introduce us later to buyer power guidelines. And so we have the context. And once we understand that our style of enforcement is informed by the value of suppliers to the national economy, the value of suppliers in terms of employment, etc., and the need for them and their sustainability, the need for them to continue to be competitive in the market, then there's a better appreciation of the direction of our enforcement. Fiona, please. Right. And so here is the legal framework, some greater detail. Now, there is an offense. The law creates an offense. The offense simply is abuse of buyer power. Section 24A1 provides that it's an offense to abuse buyer power in Kenya, or in a market in Kenya, you know, or just generally a great part, a number of markets in Kenya. But the offense basically is to abuse buyer power. It's really basic. But then what is buyer power? It's one thing to create an offense, which you call abuse of buyer power, but what is buyer power? And so the Act again defines for us buyer power as influence exerted by a purchaser, the ability to exert influence by a purchaser, and this influence is exerted as against a supplier, the intended outcome being to obtain favorable terms out of the norm, out of the ordinary terms, from those that the supplier would ordinarily take. And so these terms are favorable to the buyer, and while being detrimental to the supplier and out of the ordinary to the supplier. They are not terms that they would ordinarily deal under. And so it's an offense to abuse buyer power. I have explained what buyer power is, but what is the abuse? The abuse then occurs when a party with buyer power engages in delaying of payments owed to a supplier, delisting a supplier, or unilateral termination without a sound justifiable reason, either under the terms of the contract or generally in law. So it's unilateral termination, that's what we call delisting, or even threats of unilateral termination, where a supplier must take certain terms, or they will be terminated, the contract will be terminated. Refusals to take delivery, this occurs where a buyer presents maybe an order, okay, issues an LPO, right, requires that the supplier supply, for example, 23 cartons of item X, or 2 tons or 1 ton of item X. And when these items are delivered, they agreed with the agreed volumes and the agreed specifications, for one reason or the other, not the fault of the supplier, the buyer declines to accept delivery, either of the entire consignment or a part of that consignment. And an example of such situation would be where, for instance, the buyer realizes they are overstocked, okay, or there was an error in their ordering, you know, their systems of ordering. Now imagine the consequence where the items so delivered were specifically manufactured or processed for that specific buyer. Or imagine a situation, and so therefore they are branded very specifically. Or imagine a situation where the goods so delivered are perishable, yogurt, for instance. So what is the supplier to do with this excess that you have refused to accept as a buyer, that a buyer has refused to accept? Transfer of risks. And these are issues like shrinkage, loss, or carrying on the buyer's premises post-delivery of goods. And so this loss could occur, for instance, damage on the floor of the buyer's premises, or shrinkage, howsoever caused, theft by the buyer's employees. And so then the supplier is required to replace that which has been lost while it had already been transferred to the buyer. Another example is transfer of costs, and the one we find most commonly is a requirement by the buyer that a supplier post employees or staff on the supplier's cost to work at the buyer's premises. Okay, that's one example. The other costs, costs that should ordinarily be borne by the buyer, are then pushed to the supplier. Remember, this is a buyer with exactly what we have defined, which is buyer power. Demanding of preferential terms, a buyer demanding terms that are preferential to it as a buyer and cannot be offered to any of its competitors. This level of discounts must only be offered to me in exchange for nothing more than just the quid pro quo that was the supply and payment for the supplies. And so this supplier is caught in a situation where they're unable to offer terms similar to the ones that they're offering to the buyer, and this is affecting their ability to continue to operate because they are sort of locked in an untenable situation. But should they even move to offer similar terms, then the unilateral termination may follow. Reducing of prices to levels that are either below cost or are no longer competitive by imposition of excessive discounts, excessive rebates, etc. And then finally, we have bidding up of prices in the short term in order to exclude competitors. And then the penalties, of course, we have criminal sanction, imprisonment, and we also have a possible fine that can be imposed as a consequence of abuse of buyer power. But typically, we go for administrative sanctions, and this would be a financial penalty. This could be behavioral orders to change conduct or change modus operandi by a certain market player. If we could move, Fiona. And so we have two parties involved. You have a buyer, powerful buyer. We're shortly going to see what would make them powerful. And then we have a weaker supplier, a buyer with a superior bargaining position, or a buyer with market power, right, as against a supplier with a lower bargaining position on their side of the transaction. If you could move to the next slide. So that's a typical standard supply chain where you have raw materials which are then extracted or obtained by a supplier who then, supplies or sells them to a manufacturer, right? The manufacturer processes, adds value, picks different raw materials from different suppliers, and then processes them and forwards them to a distributor for onward progression, or directly onward progresses them to a customer, and that customer would be a retail outlet. I've indicated customer because it is their customer, it's the manufacturer's customer or the processing farm's customer. But you note that this customer, this retail outlet, is a gateway to the market for the manufacturer to the consumer. So the manufacturer needs, or even the supplier on the other end, needs this final gateway. And so the customer at that point may be able to wield buyer power. But the interesting thing you will notice is that the manufacturer at one point is a buyer as against the supplier, the blue outfit out there. And so the manufacturer is a buyer dealing with a supplier. But in a short while, that equation shifts, and the manufacturer then becomes a supplier to the customer. And so for manufacturer, you could even place a farmer right there, a supplier of, let me think, in the catering industry, there are different situations just across the economy where you have suppliers galore and their buyers on the other side. If we can move, please. So what would give a party buyer power? A buyer may have buyer power by virtue of market control, or market power by virtue of their market shares. So they are big in the market in terms of the share of the market they control is enough to give them the power to be able to dictate terms, okay, to their suppliers. Think a monopsony, but we are not necessarily talking about a monopsony. It may just be that a party, a market leader, or a party able to dictate terms outside and beyond without fear of, or rather without having to consider or think about their competitors or even think about their suppliers. So a party could actually have market power or market control, which then they can convert, they can use to exert buyer power. Again, it could also be the source of buyer power could be superior bargaining position. A buyer may have buyer power with respect to its suppliers by virtue of various factors, such as availability of substitutes, so that a supplier has no other option except to deal with this specific buyer, absence of availability of substitutes. And later I'll give us a case study where this was a scenario. It could also be a common practice in the market. The world over, the retail sector of groceries and the groceries space, supermarkets and all, this tends to be very common. Just the act of, or the arrangement by which suppliers are term takers. They do not negotiate. And you can see this, I'll just give one example. In the UK, there's actually even a retail sector, a code of practice created by the relevant regulatory agency that regulates competition in the markets, by which retailers must abide. And again, you will also see our enforcement has been in the retail sector quite a bit. You'll also see the other examples we give across the world, which I'll give us later, point us again to this retail sector. So market shares, market power, not needed. It's just the way this market operates. Okay, and so where the buyers tend to give terms, and then finally you will note that dominance is not a criteria. Under our law, the buyer does not have to be dominant to exert abuse of buyer power. And so we'll check for market shares, but we'll also check whether they have a superior bargaining position, regardless of whether they have a large market share or not. Next slide. We are still with the regulatory space, the regulatory framework. This is how we conduct our analysis. We first ask, is there a buyer-supplier relationship? If we tick that box, we move on to number 2. If there is a buyer-supplier relationship, does the buyer have buyer power? If we tick that box, we go down to number 3. If we don't tick that box, we close our investigations at that point. Same thing with number 1. If we find there's no buyer-supplier relationship, and you'll remember I said that our law is narrow, it demands a buyer-supplier relationship. So franchise arrangements where you have a franchisor and a franchisee, not going to be relevant under our law. An agent, okay, and their principal, okay, and so our law is strictly focuses on buyer and supplier relationship. Finally, if we find there's buyer power, we then move down to check, was there conduct in abuse of buyer power? The conducts I listed, is there one of them or 2 of them or 3 of them? And so those are the various steps. And once we get to the bottom, then we're able to make a determination. And I referred us to administrative sanctions as well as criminal penalties. But like I said, we tend to use the administrative sanctions almost, virtually fully. Okay. So Fiona, please. So the buyer-supplier relationship, very quickly, it could be expressed, it could be implied. This is what we dig around for. Is it recorded? If it's not, how are the parties engaging with one another? Can we read a buyer-supplier relationship in their transactions, in the way they deal with one another? And so we are not only bound to written contracts, we also ask how are these parties dealing with one another. And so and this is required by section 24A6, under which we must be guided. We must look and we must be guided by the existing agreement, written or not, between the buyer and supplier. Next slide. Okay, so is there a buyer-supplier relationship? Yes. So is there buyer power? That's the other thing we ask. And to determine where this exists, whether the buyer had buyer power, we look at a number of elements. We check at the nature and determination of contract terms. The contract terms between the parties, how were they negotiated? In fact, were they negotiated at all? And if they were not negotiated, then what does this tell us? It will typically only happen because the buyer has buyer power. Typically, commercial transactions are negotiated, they are agreed. And so where we find a standard form contract issued at the end of the year for signature, full stop, no negotiation, no discussion, then that leads us to a conclusion that there's possibly abuse of buyer, there's possibly buyer power. We check whether there was payment requested for access to infrastructure. What this basically means is that, was the supplier required to make a payment in order to engage with the buyer? Okay, you have scenarios like we have found in the retail sector, in the cases we've investigated, where the suppliers are required to pay an annual quote-unquote subscription. Okay, whenever a new branch is opened, a new retail outlet, they are required to put down some payment to be one of the suppliers. And so this is a party that is played. You can see there's no quid pro quo here. So what is the payment for? There's nothing given in exchange, because in fact, it is just simply a payment in exchange for, it's not even in exchange, because after that, any orders made, all right, or rather it is a precondition. Actually, that's what I was looking for. It's a precondition. And so it's a payment to even negotiate. Before you walk through the door, put down this amount of money, 200,000 shillings, 500,000 shillings, etc., etc. So then finally, we look at the price paid to the supplier. If we find that the price is greatly reduced to below cost or below competitive levels that make it impossible for the supplier, typically a small SME supplier, to continue to be in the market in the long term, then we are more likely to find that there's a probability of buyer power. And so the price could be reduced by discounts, by rebates, by annual deductions, etc., etc. Now, other than the act, we also look at the buyer power guidelines. We look at the concentration of undertakings in the market relative to their counterparties. What is the state of the market on the buyer side? What is the state of the market on the supplier side? How concentrated is it? What are the market shares? And I told you market shares, we look into that because market shares could be an indicator of buyer power, but they are not the be all, end all. We also ask, what is the commercial significance of the products to the buyer? The more significant the products are to the buyer, the better that buyer is likely to treat the supplier. Okay, if they are key goods, if they are what the outlet is known for, it's their lead product, then the supplier can enjoy better treatment. Then we ask, what is the ability to switch? Is the buyer able to quickly find replacement suppliers? Is the supplier able to quickly find replacement buyers? If we find that the supplier would struggle to easily switch within a reasonable time, and also there's a cost to switching. Would they need to change their infrastructure? Would they need to hire more staff, for instance? So also we check how difficult is it for a supplier to find an alternative and abandon the oppressive, quote unquote, buyer. If it's very difficult, chances of existence of buyer power are there. The nature of the product, perishable, non-perishable, okay, and so on and so forth. Perishable goods, for instance, a buyer is able to wield greater influence, to exert power over the supplier, because they know the precarious nature, the fragile nature of what is supplied, and therefore the status of the supplier. Finally, the bargaining strength of the buyer undertaking. as against the supply undertaking. And so you can see that we do not just tick a few boxes and call it a day. No, it's a tedious, long, data-driven, statistic-driven exercise. We can move on, please. Right. Now, having established that there was a buyer-supplier relationship, there was a buyer power on the part of the buyer, then we look for the conduct. Was this engaged in? And for this, we look at actual evidence. We need to see evidence that actually there was delay of payments. Here is the invoice. Here is communication between myself and the buyer the last 2 years, and I'm still, to use a Kenyan phrase, chasing my payment. Okay. Transfer of cost. I think I explained this. The buyer has a promotion. They want the supplier to pay for it. And remember, promotion, for instance, opening of a new branch. Who is this promotion ultimately going to launch and to benefit more than the other? Of course, it's going to be the buyer. Next slide. I had explained the conduct. So these are just images to sort of brighten up the whole experience. Delay of payments, and I had explained unilateral termination. So where am I? Is there a buyer-supplier relationship? I'm giving us a regulatory framework. Is there buyer power? 3, is there abuse of buyer power? If we can go to the next slide. And so we start off with our preliminary analysis. If you were to be given a torch to look into what we do within the authority, and then you zero into buyer power a department, we do a preliminary analysis. Okay, we prepare an investigation report. We call the buyer. We require them to respond to our notice of investigations. We give them an opportunity to make submissions. We give them an opportunity for a hearing conference to give oral, and they can be represented by, a legal representative. And so every opportunity is given under the Fair Administrative Actions Act. And then finally, we move on to a determination. And we could either find that no liability, we call it a day, or we could find that there's need to make certain orders. Right. If we can move on. Right. And so we have 2 sets of powers of enforcement, and I think these have gone, I've gone through the first end of the arrow. We can investigate on our own motion. What I was taking you through is when we investigate on our own motion, or also when investigate upon receipt of a complaint. Sometimes we do our own surveillance, or sometimes we receive complaints. But we ensure that the buyer is given every opportunity to explain their side of the story. And also because, like I said, for instance, delay of payments without a justifiable reason. And there might actually be a justifiable reason why these payments have not been made. And very often we close matters a lot because we find that the supplier is really at fault. Okay. We may also conduct what we call sector surveillances. If you look at section 24A2, and this is just a basic monitoring. Under the Act, we're able to do inquiries, but this is not an inquiry. This is a surveillance in order to impose certain prudential requirements. We may require a buyer to adjust their contracts, okay, and so on and so forth, after checking and establishing that the contract could actually facilitate abuse of buyer power. Okay, if we can move on. Right. And so self-regulation, again, the Act contemplates that parties can self-regulate. Intervention is the last measure. By the time you hear the authority has enforced abuse of buyer power provisions against party X, this is usually our last resort. And so we encourage parties to have contracts that have all the terms that are necessary for them to be able to resolve any disputes among themselves, or is it between themselves? Okay, then you can have a look at section 24A7 later. Next slide. As a form of self-regulation, there's also another variety of self-regulation. We may, with the input of the sector, draft for them a code of practice so that they settle their matters without, so that we are a last recourse. of sorts, okay? And we published this code of practice, and you will remember that in June 2021, we published a code of practice for the retail sector to be able to operate within. And so by the time you hear that we have enforced, there has been conduct outside of the code of conduct, and this conduct was not resolved within the code of conduct as is required, because the code of conduct, of course, operates under the Act. It's not superior to the Act. It's a creature of the Act. Okay, and so two ways of self-regulation. And so you can see by the time the authority is intervening, really, you know, for want of choice, quote unquote, I'm not sure that's what I intend to mean, but you can see we do not just jump into enforcement. Fiona, please. And so I thought to give us a quick comparative overview so that you can get an appreciation that we are not, Kenya is not this strange animal that we do not enforce, because we receive a lot of feedback. What exactly is buyer power? Why do you intervene? Why would you enter into what are private contracts between market players? Now, we are not the only ones. In the world, or even on the continent. If you look at Japan, they have their anti-monopoly acts, Articles 2, Sub-Article 9, 5, and Article 19 illegalize abuse of a superior bargaining position. And so basically, and also there are other additional statutes. And the law focuses on unfair market conduct. The idea being to safeguard and preserve, right, a fair and competitive business environment. That law is broader than ours, because you remember, as we are at abuse of buyer power, there's its abuse of any superior bargaining position by any party. And so they'll look at subcontractors and contractors, franchises, etc. Okay. The next one would be the next place, port of call. Another comparative one would be Republic of Korea. We have the Korean Monopoly Regulation and Fair Trade Act of 1981, Article 23(1), and also their supplementary laws. And you look at those supplementary laws, they regulate specific sectors, and they fall under their overall competition law, distributions, agencies, okay, and so on and so forth. If we can move on to the next comparison, and that would be Closer Home, South Africa, Competition Act 1988, under Section 8, subsection 4A. But in this case, their case is a bit different. For there to be abuse of buyer power, which is illegal under Section 8.4A, the buyer in question must be dominant. For us and for the other two comparators I've given, the buyer does not have to be dominant. And then the suppliers, for the South African Act, the suppliers must also be of a specific caliber. They must be SMEs and farms owned or controlled by historically disadvantaged persons. And then even more, this would be in sectors that the minister designates from time to time. And the idea, if you look at the purpose, to ensure the designated players, designated players are equitably treated. Look at that, because we get a lot of pushback on, no, these provisions on abuse of buyer power are not competition focused. They are more equity and fairness focused. And there you have another example of another leading jurisdiction where that is actually the focus of the law. If we can move on, Fiona. And so the impact on part C of my presentation, and the good news is that I'm winding up. Why bother? What is the impact? Now, the thing is that we hear a lot of why bother? Why do you people intervene? And I know I'm likely to receive this question, and so let me preempt it. When a party abuses buyer power, for example, a retailer, when they are able to impose terms that are totally untenable on their suppliers, I, as the consumer, get good prices. All right. And so we do get that question a lot. So I want to address it now. So in case you were asking it, it's going to be addressed now, then you can, hopefully you'll have been sorted out on that front. There are a number of economic analytical instruments that explain why we must intervene as against abuse of buyer power. Now, one of them is that there is that reduction in quantity when a monopsonist drops its demand to push down prices. A monopsony may be able to make demands, including reduced prices from its suppliers, and even drop demand in order to push for those lower prices. So I will not buy until you people bring your prices down. Because of course, if they are a monopsony, they have quite a control on virtually the entire market. Now, the challenge is that the reduction in quantity traded in that situation leads to allocative inefficiencies and ultimately welfare loss. There's again another reason why we must intervene, why we must sometimes almost look away from those good prices, which unfortunately are short term. They're not long term. They're not long term because a competitor able to exert buyer power enjoys reduced competitive pressure. Okay, in this sense, in due course, competitors who are unable to extract similar terms lose their market share to the party, to the buyer who is able to exert buyer power and therefore is getting very favorable terms. In the long run, you have competitors losing their market share, okay, may even exit the market. It may damage the industry, and Carstensen in his book points out to the downward slide of agriculture in rural America. Okay, where more and more farmers are quitting. And you've seen the protests, incidentally, in the EU by farmers. Of course, the biggest issue we've had is that certain regulations related to economic sustainability that are being pushed on the farmers are costing the farmers, and therefore they are not able to compete, they're not able to produce. But the second very key issue, if you listen in, is that the profits, as they are distributed in that supply chain, the farmer gets the least. The bulk of the profits in that supply chains settle at the retailers, door, at the retailer's shop, because these retailers are able to impose onerous terms on these farmers, with the consequence that, well, it distorts the entire and damages the entire industry. And so what will finally happen when this market player with buyer power continues to gain market share, a point comes when they can now finally operate in a manner that they are not under they do not have to be influenced by their competitors. They can act independently of their competitors. And once that they're able to do that, those fantastic low prices will go up without fail, because now this competitor, this buyer, has no reason to fear the competitors. What is called the waterbed effect, again, very injurious. Weaker competitors pay more to compensate for lower prices rendered to the party abusing buyer power. So the smaller retail outlet, so the supplier supplies to the big retail outlet that has buyer power on certain terms, on lower prices, has to suffer transfer of risk, transfer of cost. Guess who they push that damage to? They push that to the other smaller buyers. Okay, and then the effect, of course, is detrimental to the entire space, to the entire industry. Finally, suppliers who struggle under abuse of buyer power suffer reduced incomes, reduced capacity for R&D, and the more rents are shifted, okay, the more they are likely to exit from the market. And so that explains the impact. If we can move to the next slide. And it also explains why we enforce. And we have some case studies here. And just while we are still on the impact, in the course of our enforcement, what we have established is that that is the reality of SMEs exiting markets. Later, I'll take us to orchards. There's a case we determined as against Majid Al Futtaim, Carrefour, and this was in 2020. And by the time this supplier was presenting its complaint, the supplier had actually closed shop completely, unable to trade anymore. And so there is one very, what is the word? Yes, okay. It's not a good thing. Okay. Now, case studies. Before we even get to the enforcement, I want to give you a feel of the number of cases we do, because the one time you hear us, that is not all we are doing. The one time you read abuse of buyer power against this retailer, penalty of this amount, we are doing much, much more. And that table just gives you an indication. 9 cases received in 2018-19, finalized 4. If you scroll down to 2022-2023, last financial year, 116 cases, a carryover from the previous year, and new ones we started. We closed 79 at the end of the financial year, because I want you to see that we're not just enforcing one case in the retail sector, or 2 cases in the retail sector, or 5 cases in the insurance sector. We have lots of Kenyans walking into our doors. Okay, if we can move to the next slide. And I see I'm out of time. Again, just a bit of the impact of our enforcement. Delayed payments recovered from the retail sector, 2.25 billion shillings. Kenya shillings, 132 million delayed payments recovered in sectors other than the retail sector. We have a retail code of practice issued. We have template contracts we have prepared for use by parties that are unable to draw their own contracts. And finally, we have managed to procure 400 million shillings MSME. We managed to MSME procurement, an undertaking to procure from local MSMEs up to the tune of 400 million shillings, as well as offer them supplier training for supply to multinationals. Next slide. Right. Again, just a bit more of, just to give you a feel of what we do. Those are the delayed payments as recovered year by year by year. And then the table below gives you a feel of the sectors we are working, we have enforced within. So transport, branding, marketing, telecommunications. And this is only 22-23. If we give you the broader array, we've enforced in about 23 sectors. And I can see subcontracting isn't here. I can also see catering and hospitality, rather hospitality isn't here, but there is a feel of what we do. If we can move. Okay, here are the case studies. In 2020, we made a determination against Majid Al Futtaim, also known as Carrefour, operating here as Carrefour. Now, allow me to go to bullet point 2, Majid Al Futtaim 2023. That would be last year. Many of you are aware. Now, unfortunately, this case, I'm not able to give us the detail beyond the press statement, which we issued on 19th of December. I can also, I can also send to, other than the press statement, all that was in the public domain, but also there was an interview of the same date on Citizen TV News at 9, so if you can search for that. And then on the 21st, again, there was a thorough explanation at an interview I did in the Situation Room, Spice FM. That will give you the information you need. Reason that I cannot get into details is that this specific buyer has presented an appeal to the competition tribunal, and so of course I would not want to go into detail regarding the matters that are at hand as we speak. But I can discuss with you the 2020 matter. Now, what happened in 2020 is that we investigated a complaint received by an MSME. This was actually a very small firm in the business of processing of probiotic yogurts for sale to retail outlets. And the complaint was that between 2015 and 2018, this market player had entered into contracts with Majid Al Futtaim and had continued to supply yogurts, okay, probiotic yogurts. But at the beginning of at the end of 2019, while parties were negotiating, or rather the end of 2018, as parties were negotiating to move into 2019, the supplier attempted to negotiate because previously they'd just taken these contracts as they were. The reason being that, and from this, the information I'm getting is actually, you can actually get it from the Competition Tribunal determination. You'll find it on kenyalaw.org, Competition Tribunal, case number 06 of 2020. When the small supplier attempted to negotiate, the consequence was termination of contract. The reason that the supplier continued to supply was under these difficult circumstances was that, you will remember, that was about the time shortly earlier, 3-4 years earlier, Nakumatt had exited the market, and this was the main supply. This was the main outlet for this supplier. Remember, these are probiotic yogurts. They are a premium sort of good, so that at the end of the day, you must target a specific clientele who will shop in specific malls. Now, what had happened is that at the time, the finding was that Carrefour had taken 5 out of 7 of Nakumatt's former outlets, and so had stepped into that footprint. And so the complaint, as you will pick if you look at the tribunal case, was that there was excessive rebates, 10%, 1.25%, 5%. There was onerous rebates that greatly reduced the price at which the supplier was supplying. And so upon review, we established that yes, this was actually a situation of abuse of buyer power, which was confirmed by the Competition Tribunal because the retailer then appealed. And we required that all contracts of this retailer be reviewed to remove all terms that enable, that facilitate abuse of buyer power, among other orders, including a refund to the specific MSME. And so that, again, our determination was confirmed by the tribunal, and so our findings were affirmed, and the tribunal found in the authority's favor with regard to application of listing fees. There were listing fees that had been applied, what I called a payment for access to infrastructure, application of rebates. The tribunal confirmed indeed that there'd been a transfer of commercial risk and that there had been unilateral termination. And so that's just one case. How did we establish this? We did the step-by-step analysis I took you through under the Act, and also we checked for economic dependency under the buyer power guidelines. I've put CAK and Unilever PLC here because this was a settlement, the terms of which, as agreed between the parties, a party is entitled to seek confidentiality. And so I would not share the terms, the nature of the investigations, but I can share the findings, or rather I can share the settlement agreement reached upon. And Unilever, without conceding liability, it's important that I state this, without conceding liability, then undertook, without conceding liability for abuse of buyer power, undertook to procure from MSMEs to the tune of the money that I have indicated in the previous slide, also to train MSMEs, okay, on procurement requirements. And so those were just, that was a settlement agreement. The reason I raise this is so that you can see that also we have situations where we actually have out of court, or other settlements under the Act. If you can move to the last slide. I do hope that's the last one because I suspect I've kept us enough. Settlements, important to note, can only be with the authority. So that if a buyer and a supplier presents a complaint and we commence investigations, then the supplier and the buyer cannot step out and agree all right, fine, we're going to call this one a day, and that's it. The Section 38(1) does not envisage that as a possibility. Again, more importantly is the fact that this is a buyer with buyer power. So I'm twisting a supplier to accept a negotiation is a real possibility. And so the Act foresaw that, and so the authority may, I have underlined, may enter into an agreement, and the agreement entered into need not include a penalty. And I took us to CAK and Unilever. You can refer to that Gazette Notice 581, 20th January 2023. Next slide. Yeah, thank you. I can see I am over time. My apologies. I'm open to questions. Thank you.
Thank you so much, Daktari. I think at this point, I will not attempt to do a summary based on the time. So probably we can just move directly to the question and answer. So at this point, in case you have any question, you can write it in the chat and I will read it out. Or if you want to ask Dr. Njako directly, you can raise your hand and then the comms guys will help me in unmuting you, and then you can ask your question directly. So I would first give the first chance to anyone who wants to ask their question directly. Okay. Then I guess, Dr. I can read out a few questions for you. There is one. Yeah. Okay. So there's one from Mr. Arthur Namu, and he asks that the government has big buyer power and continually abuses that power by delaying payments to suppliers at both levels of government. This is an existential threat to many SMEs, and in some cases has occasioned suicide of individuals. What is the Competition Authority doing in this area? Then Olunga asks, what happens when the perpetrator files for bankruptcy, for example, a supermarket chain that is closing down? Then Juma asks, it appears to me the Competition Authority is acting in activism for, quote, protection, end quote, of small players at a disadvantage to the perceived big players. With this in mind, I feel small suppliers are likely to play victims, whoop up emotions so that you can punish the big boys without getting to the root of the issue. So how do you ensure neutrality?
Okay.
Yeah.
All right. Thank you. I'll start with Juma because I hear him. All right. And the question has really been put well. Thank you, Juma. How do we ensure neutrality? Because the risk is real, and it could be very easy to swing out to protect smaller players who play quote unquote victims. You will recall that I mentioned that we do have levels of investigation. If there isn't a buyer-supplier relationship, we close the matter regardless of how small you are, okay? Or how pitiable, you look, right? Allow me to use that. Then we move on. You remember those layers. It's impossible to take a matter through that kind of sieving process, taking it through a level by level by level, and still find a buyer that should not have been found liable. Okay, so the reality is that if you look at our annual reports, you will find that up to about 45% of our cases, we close them. We find that there's no liability here. The other number, almost 90% of them go by way of negotiation. The buyer talks to the authority and says, okay, fine, I concede. Can we adjust this? Can we adjust that? Can we adjust the other? And so we have, the Act has three, requirements that we must tick. Then after that, we go down to the buyer power guidelines. Then not only that, we get to hear the accused party. They can come to the offices, they can seek an oral hearing. This is actually recorded. We even record so that, and we give them the recording so that they have a record of exactly every step of the oral hearing. And so you can see we ensure that we adhere to the fair administrative actions, or rather fair administrative action. And so not to worry, we ensure that we are not activists. We're not acting, we are not interventionists, actually that's the word, where we're just intervening left, right, and center. We appear to have an industrial policy of ensuring that SMEs are treated as follows. The government, this would by NAMU. The thing is that the authority may progress an action against a government agency, or a state corporation or a local authority. Section 5 allows us to do that. Section 5, to be precise, Section 5, subsection 1. And so, but the catch is here only for as long as they engage in trade. And so our act sort of limits us to that extent. And I do know that there are interventions that the National Treasury has put in place with regard to delayed payments, but the authority's mandate is limited to situations only where the purchase is made for purposes of engaging in trade. But I do know also that the PPRA also does have certain regulations towards that end. There was another question that was from Olunga. When a perpetrator files for bankruptcy, the competition regulations or regulations under the Act require that then we must end our investigation. So we terminate investigations once a party files for bankruptcy, because any investigations you realize would be in vain. Finally, we're able to make a determination, and our powers would then be, our powers are really limited beyond that. So Fiona, I don't know if we have other questions.
Yes, I have two more from Juma and Jane. So Jane asks, we understand that in one of the cases you mentioned, only one supplier complained. What was the justification for requiring the retailer to amend all contracts with all suppliers? And then Juma asks that you had earlier indicated that CAK has the power to conduct both surveillance and inquiries. Does CAK engage specific bodies to do this, or does it do this on its own? Also, are these reports available to the public upon request?
Right. Thank you. The reason, and this answer is to Jane, the reason that we required all contracts be what is the word, be varied or be adjusted, and again, which the tribunal confirmed. So again, this question would be perfect to be addressed to the tribunal, because the tribunal still found that our finding was fair and was within the law. But if I can explain the rationale from our end, is that we had received concessions from the party enforced against, that all their contracts are in the state, or rather were standard in this, they were standard form, they were issued to suppliers, and that they all contained these rebates of this nature, and so on and so forth. And so rather than wait for one complaint at a time, Section 36, which enables us to issue administrative orders, does not limit us to the nature of those administrative orders. So that would explain the breadth of our determination. We conduct the surveillance. We do definitely engage parties that are relevant in the specific area. And I'll give the example of sector associations, okay, BMOs. When we do conduct such surveillances, we'll work with them. Let me give an example. We did a sector surveillance just prior to COVID, the year before COVID, and shortly running into COVID. We worked with the Retail Trade Association. We worked with the Association of Kenyan Suppliers. We worked with CAM. We worked with the Chamber of Commerce and Industry. Long and short being that we would not succeed in a surveillance on an inquiry unless we are able to work with these sector players. And so we engage them, because you note that this is actually not an enforcement. It is more, allow me to use data kind of gathering. So we're getting information to guide the sector. So we're not at war. And so we have tended to get very good support. I guess, of course, if you're not at war, people are willing to engage. I don't know if there are others.
Yes, Dr. they are. But before I read them out, Leo Kemboy has a question. Leo, you can unmute.
Yeah. Thank you, Dr. Njako, for your brilliant presentation. I've followed your work over the years and must contend that you are one of the leading minds in economic regulation and competition. And so I have three questions. First one is, given that a significant part of Kenyan economy is now in form of what we'll say value chains, are there market studies that show monopsonies within those value chains? Because we've realized that some of key sectors have one or two firms in specific parts of those value chains. The second question is economic impact assessments on buyer power in key sectors. As an economist, I'm not only concerned about consumer surplus, but also I'm concerned about the producer surplus, because it gives the most optimal point in the economy. The third question is on the market inquiries. We've seen one of the latest studies that CAK is embarking on, and I know it will cover not just buyer power, but cover other things on dominance questions and the rest in the animal feed. Could those kind of inquiries go into other sectors, like, for example, healthcare? Because so for example, one of the things that we know is some of the biggest hospitals in the market buy drugs at very low prices, but they're the ones who sell at the highest prices. And what form are market inquiries constrained by resources at CAK, or it's something that you'd consider to expand to other sectors? Thank you. I hope I'm clear. Thank you.
Yeah, yes. All right. Thank you very much. Thank you, Bwana Kemboy, and thank you for the compliment. I appreciate it, Sante. Market studies showing monopsonies. So far, you realize the authority has been engaging in quite a number of studies, but again, we're not a very old agency. We are starting, I believe, our 12th year. I know that's old enough to be doing a few things here and there, but of course, there's always the challenge of picking up and then expanding. You realize that's various constraints. None so far, but definitely challenge taken. What I will say is that we did a market study of the retail sector in 2016. This can be shared, and I believe it's on our website, but you can always reach out in case it's not on our website. And even the State Department of Trade one in that sector, which is what established that there were challenges in this specific, in these value chains. Economic impact assessment, we have enforced abuse of buyer power for this is now our 5th year. And so we have needed to first of all establish the enforcement, establish our routes in terms of enforcement, and then progress to looking into these issues of economic impact assessments, specifically looking at issues of producer surplus. What is the effect? How are the state of the markets and the value chains? And so again, challenge taken. Thank you, Kemboy. And then finally, The market inquiries, yes, we are doing animal feeds, you're well aware. And yes, we do intend to expand to the other areas. And finally, yes, of course, there are the usual constraints. And so other than to respond to the budgetary constraints, we are then forced to prioritize. We're forced to prioritize certain areas and prioritize what is most key. But definitely, we are moving in that direction. The idea being to scope the entire economy and identify where the challenges that demand enforcement lie. So I hope I've addressed your questions. Fiona, do we have other questions?
Yes, I think this is a very interesting topic to many. So
Yeah.
I have two questions from Mukeni, and
Yeah.
she asks, where an appeal has been filed and CAK's decision stayed by the court or the tribunal, isn't CAK stopped from implementing similar decisions until the appeal is determined? Then she also asks, where an appeal has been filed and CAK's decision stayed by the court, I think it's the same, right?
The
Isn't
same.
CAK stopped from implementing similar decisions until, yeah, it's the same question. Then there's one from Mumbi Gitau. So how does the CAK respond to a defense by a party that states it is a willing buyer, willing seller contract? More so in the case where the investigation is taken up by CAK's own motion. Then John Mutua asks, does CAK engage in assessment and red flagging market dominance or monopsonistic behavior to preempt buyer abuse? I hope I didn't go too fast, Daktari.
No, it's okay. I'm
Okay.
also seeing the time,
All
not to
right.
worry.
Okay.
I'll just
Yeah.
go through them. Problem. Where an appeal has been filed and CAK's decision stayed by the court, I think the very operative words there are CAK's decision in that specific investigation is what has been stayed by the court. And so whether CAK is stopped from implementing similar decisions, one, CAK is not stopped from continuing investigations as complaints are received, because one, any stay issued will relate to that specific decision. And short of requiring that a regulatory agency pause while an offender continues with similar conduct, then we of course are able to continue investigating. And again, it's important, I think, for me to indicate that it is the party under investigation is of course at liberty to raise. Remember, we said we give an opportunity, fair administrative action. They're at liberty to raise this issue and indicate that, look, we have a stay. And then we will, of course, if justified, we are able to stop. But we cannot stop investigations that have not been stopped by the court. So the stay, we will not investigate. Where the stay is clear, your hands are held going forward. Otherwise, we would actually be allowing a party to engage in conduct A with regard to party B, okay, run on appeal, and then continue to engage in the same conduct with regard to party D, E, and F. Let me move away from that. How do we respond to a defense, willing seller, willing buyer? The reality is that their contracts are illegal in law. And I think every lawyer will know that. And so we cannot have, that is not always an appropriate defense. There are corners it will be, but as long as the law has made it illegal to engage in certain conduct, then a party cannot come forward and say, look, my quote unquote, and I use this very gently, quote unquote, my victim is okay with the abuse that is going on. They are willing. So you could argue willing buyer, willing seller. You could enter into a contract and agree on it till the cows come home, as long as the contract is contrary to Section 24A one, then such matters will of course be subject to our investigation. The other thing is, do we engage in red flagging? Definitely yes, Bwana Mutua. Yes, we do. I did indicate that we can investigate matters suo motu, or we can also conduct market surveillance. And the important thing is to note that as a consequence, we can demand, we can impose prudential requirements that would then preempt. You know, you must conduct yourself in this way and that way and that way. And that, by requiring that the party engage in that manner, then we preempt buyer abuse. Yeah, I think the appeal case is the same one that I had addressed earlier. Okay. Yeah. I think, Fiona, I've answered all your questions.
Yes, you have. So is there anyone before, so that I don't lock out anyone as we wrap up? Okay. All right. I guess that's it. Daktari, thank you so much. So, ladies and gentlemen, as we bring this webinar to a close, first of all, I want to extend my sincere apologies to every one of you for the delayed start. And we really appreciate your patience and understanding as we tried to, resolve the technical issues and decide whether or not we are postponing the webinar or continuing with it. So thank you so much for just staying on. And I think we've taken 23 more minutes of your time from when we had anticipated to wrap this up. I want to express my gratitude to Dr. Njako of the Competition Authority of Kenya for your patience as well and just adapting to these unforeseen circumstances. Despite that delayed start, Daktari, you delivered an insightful presentation that was very informative to all of us here. I am also thankful for the participants, all the 50 of you who tuned in and just waited for the webinar to start, and also just for your questions. They've been as well very thought-provoking. And I also want to acknowledge the IEA team, specifically the ERCP team for organizing this webinar, the communication department, the IT guys for making this a success. That hasn't gone unnoticed, and we continue to appreciate your commitment to having such informative webinars. So thank you once again, everyone.